We've got a 1 hour presentation for you today. My name is Billie Tarascio, and my co-host is here, Robin Barrett. Robin, why don't you go ahead and introduce yourself?
Hi, good morning or afternoon, everybody. I'm Robin Barrett. I'm an attorney, family law attorney here at Family Law, and I work with Billie, and I'm very happy to be here. Billie, thanks for inviting me to join you today.
Absolutely. She meant modern law, but we do family law. And Robin is, she's a trial attorney. So she was a former prosecutor, and she is truly a trial attorney. And that's not true for most family law attorneys. Most family law attorneys don't necessarily have that pure training in trials, which makes her just a shark in the courtroom and super fun to watch and great to work with. And I'm very happy to have her here today. And we're going to be talking about how to prepare your testimony. So this is everything that you need to know in order to set your clients up for success when they are testifying, be it for a deposition, custody evaluations, trial. We'll also probably touch on things like court-appointed advisors and parenting conference. It's very specific to the legal process in Maricopa County. So, Robin, why don't you go ahead and walk us through the basics?
Okay, so there's different types of witnesses that we use for trials or any kind of evidentiary hearing. Obviously, you want to prepare your actual client who's a party in the case, and then you also want to prepare any witnesses that are going to be testifying on your client's behalf. And it's really important before having an evidentiary hearing or trial that you properly prepare your witness, especially because in family court here in Arizona, Maricopa County specifically, trials, you don't get a full day or 2 days for trials unless it's very, very unusual circumstances. So typically trials are like 3 hours or less, and half that time is appointed to each side. So you want to make sure that you prepare your witnesses to be clear, concise, and to the point. People have a tendency when they're testifying to ramble on and on out of nervousness, or sometimes they go blank when they're on the stand. So it's important to go over the questions that you're going to be asking them. Obviously, I don't typically send clients questions ahead of time because I want the answers to be fresh. I don't want them to be canned, but I will prep them in advance to try to avoid saying things that might be damaging to the testimony, and to try to highlight certain points that are more critical to their case.
Absolutely. I recommend a minimum of 2 sessions. And in the first session, I like to have just a free flow conversation. I have not scripted my questions out. We've written the pretrial, so we know our strategy. We've written the pretrial, and then we're just going to have a conversation and kind of discover what's powerful. I always record that session, and I always have the client record that session. And that allows us to kind of get to know each other's flow. And that would be well in advance of trial. You don't want to do that on the eve of trial, but then on the eve of trial, you want to come back. And at this point, we're all honed in. We've at least 2. This would be the minimum. Sometimes you have to do more than that. But then by the time you get to ready for trial, at that point, we lawyers we know our outline. We know what our questions are going to be. Some lawyers write the questions in advance. Other lawyers just have an outline. How do you prefer that, Robin?
Well, I write my questions in advance, and then I kind of do them in sections. I'll start with like a basic foundational questions, name, occupation, how long have you married, names and birth dates of children, what do you do for a living, that sort of stuff. And then I'll start, like you were kind of explaining earlier, I'll do like a big panoramic. Please explain to the court why we're here today. Right. And I'll start there, and then I'll narrow it down and talk about certain situations. And I'll try to write my questions in advance based on the points that I want to make to the judge in order for the judge to be able to rule in our favor.
Mm-hmm. Sometimes lawyers have a tendency to skimp on witness prep. And the whole point of today's presentation, maybe before we go any further, is that is a serious mistake, because if you're going to trial, then their whole life is on the line. And this is time that clients are usually happy to pay for, and that lawyers tend to, in my experience in family law, undervalue this time. So setting aside enough time, turning off all distractions, that's for you, the lawyer, and for you, the client. Turn off your notifications. I understand if you have to kind of keep an eye on your kids, but other than that, like, this needs to be time that is taken seriously. The next thing to be aware of is nonverbal communication. Most lawyers don't spend enough time talking to their clients about this. And so this is a presentation that you can give to them. It's something that you can do to write your own policies and procedures. You might want a handout on nonverbal communication, but most communication is nonverbal.
Correct. Absolutely. And I do speak with clients about that when we're prepping. I remind them about not eye rolling. And it's also important, like even when they're not being questioned and when they're just sitting there next to me at the table, not to eye roll if the person that is actually testifying is saying things that they don't happen to agree with or are not pleased with, to avoid eye rolling and making faces, because judges do look up and see that, and it does not reflect well upon your client if they're making facial expressions that are inappropriate.
Absolutely. So you know that the judges have thousands and thousands and thousands and thousands of cases, and they may not remember your case, and they may not particularly care about your case, and they certainly don't care about your case as much as you care about your case. That's just a given. So with those things in mind, with those very real time constraints in mind, you should have a strategy going into court about who is my client, and then pick a character that the judge is going to know. Like if you're a teacher, and that's why I've got dress your part over here, this third section. If you're a teacher, look like a teacher. Look, even if that's not how you dress when you go to work every day. If you're going into court and you're a teacher and you're trying to convey that I am everything a teacher is, I am attentive, I'm nurturing, I'm structured, I'm responsible, I don't make a lot of money, I'm a civil servant, then show up as that character. And so decide in advance, who is my client's character? And if you're representing yourself, it's who am I? And so when you all, many of you know that I have kids, and we had to do a modification. I represented myself for that modification, and I needed to be out of lawyer role and into mom role. And that meant I talked like a mom, I dressed like a mom, I tried to turn the lawyer mode off. And so you need to be thinking about, who is your client and how do you help them be more of that, so that their body language supports that, the way they dress supports that, the words they use and the tone all supports the strategy of the case.
Absolutely. And I'm looking at the picture on the right. I was chuckling inside to myself because, I tell clients, like, look, I love your tattoos, but the judge might not. So cover them up. And I always say, ask me, well, what should I wear? And I say, dress as if you're going to church, synagogue, maybe a casual wedding. I want you looking conservative and well put together. And I sometimes will do a little wardrobe check with them prior to make sure that there's no assets hanging out, and that they look presentable, and that they're making a positive appearance.
Absolutely. In general, courts are probably the most formal place you might be. It's more formal usually than church. It may be more formal than, even some weddings. Judges are, traditionally very traditional. So whatever you are, whoever that character is that you're presenting, you want to take that character and then make it a little bit more conservative, a little bit more traditional, a little bit more careful.
Right. I always say err on the side of conservative. If you're not sure, take it down one notch.
Absolutely. Yep, absolutely. Here are 6 general rules for testifying. So we're getting all these generalities out before we dive into, okay, what's specific for the deposition, specific for the CFE, specific for trial. Do not start to answer the question until the question has been completely asked. This seems obvious, but it may not be. Pause before answering to make sure that you understand the question, and give your attorney the opportunity to state any objections. Use this time to think about the question and make sure that the answer that you're providing is in direct response to the question that they asked, not the one that you think they should have asked. Which leads us into rule 3.
Do not volunteer information. That people have a tendency to do that. Somebody will ask you, so where did you go on Monday, April 5th? And then it's just a general question, but then they they keep answering well beyond the basic answer of the question, or worse yet, on cross-examination, if a opposing attorney asks you a question, and instead of just answering yes or no, you explain yourself, then you've given them rope to possibly hang you later on. So you want to keep your answers short and concise and answer the question directly.
Absolutely. For those of you who've been watching the Amber Heard Johnny Depp hearing, I mean, this is such a great insight into watching testimony. You can see that people on social media are analyzing the testimony of the psychologists, the expert witnesses, and they're not always answering yes or no, but they're very well prepped. They know exactly what their answer is going to be. Do not guess at the answer. If you do not remember, just say, I don't know, or I'm not exactly sure. And then you can say what I remember is, and provide only the information that you are absolutely certain of.
You want to go next? Answer the question asked, not a variation of the question or the question you think should have been asked instead.
Right. That happens all the time.
Absolutely. Yeah, be very direct and advise your clients to be very direct when they answer questions and not to go off on tangents.
Right. Your time is so limited. You really, and family law is hard because you are trying to take your entire life and everything that is important to you and everything that's the most important to you and put it into like a 20-minute summary. And the best way to do this is by understanding what is most important to the judge and then gearing your testimony all back to those big ticket items. So you don't want to go into court without having prepped all of that. Understanding and making sure your client understands this is what's important to the judge and why. Go back to this. And then pay close attention when your attorney may be asking you to provide privileged information. So there are certain objections, certain information that you should not reveal. Robin, you want to talk about what privilege is?
Sure. Privilege is something that provides you with an opportunity to not have to disclose certain information. Like anything that you discuss with your lawyer is considered privileged information. It's an attorney-client privilege. And so if opposing counsel asks you on the stand, what did you tell your lawyer? Well, that's privileged information. Any communication, verbal or written, with your attorney or a member of your attorney's staff is considered to be privileged. Also, there is the priest penitent privilege, which isn't utilized that much, but actually came up very recently in one of my cases where there happened to be a pastor who was doing some kind of marriage counseling, and I reached out to him to ask some questions regarding some potential domestic violence, but he could not speak to me because of the priest penitent privilege. So there are certain privileges which are very holy, pardon the pun, in our legal world, and you cannot violate certain privileges.
That's absolutely true. And you should know if you invite, so anything your lawyer tells you is privileged. Anything you tell your lawyer is privileged, as long as it's not stated in front of third parties who are not part of your legal team. Yeah. So the risk, and many people in family law do bring in third parties to attend and just be there for moral support, helping an extra set of ears. And the real risk with that is that you are destroying that privilege. You are opening yourself up to somebody asking you, what did your lawyer tell you? Even then, judges typically won't make you answer in family court, but it's something to be aware of. And the other thing I want you to be aware of is the Fifth Amendment right against self-incrimination. Mm-hmm. This is really important. And can you talk about that, Robin?
Sure. I actually had this come up in one of my evidentiary hearings recently, where there was allegations made against a particular individual regarding sexual abuse. And instead of answering the questions, this person invoked his right against his right against self-incrimination, and he invoked his Fifth Amendment right. So that protects him against possible criminal sanctions down the line. So that does come up. I wouldn't say often, but sometimes in family cases, mostly criminal court, obviously, because the defendant has a right not to testify. But that doesn't happen in family cases as often because it's civil court, not criminal court. But if there is some kind of criminal component where somebody at some point in time could be charged with a crime, then it would be in their best interest to invoke their Fifth Amendment right in that particular case.
Absolutely. If you have pending criminal charges or potential criminal charges, the Fifth Amendment is something that you should be talking to your client about. Everything, every answer, every decision you make, every piece of testimony should revolve around your strategy. Your strategy should be your homing beacon. Always come back to that. So here is a system to help you identify your strategy. And this can be hard, even for attorneys, to figure out what is the strategy in this case. So here is a system that you can use if you're a newer attorney and you're listening, to help you come up with a strategy and really decide, cipher through all of the details and figure out what is our strategy. First, you identify what legal issues are in dispute. Those at the highest level are, property division, custody, child support, biggest issues. Then you look to the statute for each issue and you determine what are the elements of each issue. So for instance, in child support, to figure out a child support calculator, the elements are going to be mom's income, dad's income, childcare expenses, parenting time, all of those things. And then you look and identify what of those issues is in dispute. Does everybody agree that mom's income is mom's income, or do we have a fight about that? But when you have a fight about it, then you go into the sub issues. Is she underemployed? Could she be making more? Is she hiding money? And then you would basically drop down or pop down, your outline would get bigger. But once you do that, once you identify every single issue, every single element, and then you cross-reference the evidence that you have with the elements, that's how you determine what it is that the court has to decide and what is most important. And then you want to determine what's in dispute or not. That's where discovery can be a very useful tool. So I don't like to go into trial guessing that we all agree on mom's income. So I want to use the interrogatories or a deposition or some discovery tool so that I know through officially, not unofficially, but officially, that we all agree on mom's income. Do you have anything to add on that, Robin?
Yeah, I think the best thing to do is that if you can, like you were saying, nail down the issues, identify what they are, and then build your testimony around what those issues are, it will only strengthen your case in the end.
Absolutely. The other really benefit of doing this is many times family court cases can be very complicated. There can be a lot to cover, and it can be easy to forget things. But if you have this outline of every issue and every element, and you take the time to fill it out and then put it in your pretrial statement, that is how you avoid committing malpractice. That is how you know that you didn't forget to mention the debts, that you didn't forget to mention, a reimbursement claim. And so I do see many times where people will end up with family court orders that have left things out. And this is a great way to make sure that that does not happen. And then once you identify what evidence is still in dispute, that's how you know what evidence you need. And that's how you determine, do I need to subpoena somebody? Do I need an additional witness? And Robin is great at identifying where she needs additional witnesses. Can you talk about that?
Oh, absolutely. Yeah, this is probably my favorite part of being a lawyer, is finding out which witnesses are going to help make your case stronger, who is going to, who brings value to your case. And this is something that I think a lot of lawyers don't utilize enough, is sometimes you got to do a little bit of digging. Part of being a lawyer is also doing a little bit of investigation and trying to, ferret out, certain people that can be beneficial. Like, for example, in a domestic violence case, if you're talking about, if your client is alleging that their, spouse is an abuser, sometimes these kind of things are hard to prove, even, when there's no bruises or cuts or photographs. Sometimes it ends up being just a he said, she said. But if you can find maybe previous victims of the same perpetrator that are going to be willing to testify on your client's behalf, then you've added a valuable resource to your case, because this person can help develop testimony that can help show the judge that there has been a pattern of abuse.
Absolutely. And the statute specifically says that those witness testimony of past abuse will be heard in family court. So we often think we don't have time or the judge won't care because it was so long ago. It's just not true. you should do it. Like if you should put on the very best case for your clients. And that means bringing in the witnesses to address disputed issues. So domestic violence is such a good example because, you have mom saying X and dad saying Y. You have a disputed issue that can't be figured out through a deposition. That's an issue of credibility. But you are removing the chance of credibility, just pick one, by adding another witness to your side. Now the judge has to decide that two people are less credible than one. Now you've done your job as a lawyer. So let's talk about depositions. What's a deposition?
A deposition is an opportunity to question a party or a party in the case, or a non-party, which would be somebody not one of the parties in the case, just a regular witness. It's an opportunity to ask them questions under oath. And depositions are great ways to lock in someone's testimony, so you know exactly what they're going to testify to at the trial. Now, the reason that they're such valuable tools and not used enough, in my opinion, in family law cases, is because once you lock in that person's testimony, then you have an opportunity to impeach them if they waver from that testimony at the actual trial. And because depositions, the opposite attorney will be there during the deposition, so they have an opportunity to object. The deposition, once it's certified after the completion of the deposition, it becomes substantive evidence. So that means it can be used for impeachment purposes and also substantive evidence in your trial or evidentiary hearing. So they're valuable tools that should be utilized more frequently, in my opinion.
I completely agree with you. I think they should absolutely be utilized more frequently. And so here's the basic takeaways. You can take a deposition after a case has started. So you cannot take a deposition before you filed a petition. If there's not a pending action, there's no deposition.
And you're 30 days too. You can't depose a person within 30 days of filing for the petition unless there's agreement of the parties or leave of court.
Yes. Yeah, that is true. You are allowed automatically to take the testimony of the parties or their current spouses or an expert witness. Anybody else, you have to have an agreement or a court order. And it's really interesting to me that it says spouses, not, live-in partners. So, so it's important to know who can be deposed, and then what happens during the deposition. Now, Robin was kind of talking already about the purpose being to gather information and to lock in testimony. I think for you lawyers out there, it is, or if you have been accused of domestic violence and you are representing yourself, I think those are some of the most important depositions to take, because you want to ask before you get to trial, what is every single allegation of domestic violence? We had a client who we represented for a long time, and the judges switched in the middle. So everything was going well. Everything was going well. He had started out with equal parenting time despite her false accusations of domestic violence. They had been exercising equal time. The cops had dropped the charges. There was no order of protection. We thought he was fine. We got to trial, new judge, and she had come up with a whole slew of other accusations and incidents that we weren't aware of. Now, technically, you're allowed to object because you're due notice of that, but the court also may let it in. If you do a deposition and you ask the question in advance, now you have an impeachment issue. You mean to tell me that when I asked you about every single incident of domestic violence and you never mentioned that 2 months ago, you're now telling me, and this court, even though a deposition is testimony, so it's not just like, well, I was lying to you. It's testimony. They have to swear when they take a deposition under oath that the answers they will give are the truth, which makes impeachment so much more powerful with a deposition than with a text message or an email or whatever.
Absolutely.
So let's talk about the objections issue. So usually when you're testifying, your lawyer's objecting, and you can't really make those objections to depositions. Can you talk about that?
Yes, you cannot typically make objections during a deposition. I mean, there's limited opportunities to object. Your lawyer should be objecting just so that they can preserve the objection later on if you want the judge to rule on it. But there are certain objections which your lawyer can make during the deposition. For example, Fifth Amendment privileges. Like we discussed previously, if you're potentially incriminating yourself, then your lawyer can object. And also privileged communication, you can object to that. Also, if the opposing counsel is asking questions that are inappropriate or abusive, harassing, that's another opportunity for your lawyer to object. Otherwise, everything's fair game, and you have to answer the question, and your lawyer can object and then preserve the objection, and then later on the judge can rule if you set it for a status conference or some kind of hearing prior to the trial to go over the deposition testimony. The judge will rule at that point in time whether or not the testimony comes in or stays out.
Absolutely. So the way that the objections work is you can object to form of the question, you can object to hearsay, but you still have to answer the question unless it is privileged, protected under the Fifth Amendment, or let's say the court has previously said, no, you can't ask her about her past sexual partners. Now we don't have to answer it even in the deposition, but otherwise they want to ask you about an affair. You have to answer. And your client has to answer, even if it's irrelevant, even if it would never get into trial, your client has to answer the question. So depositions can be extraordinary tools for discovery. If a question's on the table, you have to answer it. You cannot take a break and your lawyer can't tell you what to say. So lawyers, when preparing your clients, should be telling them what the rules are before they get there. You shouldn't be writing them notes. You shouldn't be coaching them. You cannot tell them how to answer. You can't take a break when there's a question on the table. The question needs to be answered and then you can take a break. Defending depositions. So we talked a little bit about taking depositions, what you can ask, why you would take the depositions. How do you defend a deposition, Robin, as a lawyer?
Well, I always tell my clients that they have to be very honest. Obviously, don't lie. We know that this is a truth-seeking process. So we want to make sure that we're honest. And if some of the questions might be damaging, I would advise my client, you've got to tell the truth. But when the opposing counsel asks you a question, be very specific and be very concise, and don't ramble on offering other information that is not relevant to the question posed.
Right. It is not your job to convince the lawyer taking your deposition that you're right. That is so hard for people. It is so hard for them not to over explain. But the best thing that you can do is prepare your clients to not give any more information than is specifically asked. It does not benefit you to provide extra information about anything. You're not on trial. So
Right.
it's a very different way of testifying. Other things that you need to keep in mind is video versus audio.
Mhm.
And not playing games. Many times I will watch my clients or some clients start arguing with the lawyer or trying to get coy or trying to outsmart them. Have you ever encountered that?
Oh, absolutely. It happens all the time in depositions. And it's like you were talking about audio versus audio visual. I actually prefer video depos because I think, like we were talking earlier about nonverbal communication, is so it provides so much more information on what the person's actually saying. And I mean, when you're doing an audio, an audio visual type of deposition, and you see the person's facial expressions, they might be saying one thing, but their eyes are telling you something completely different. So for me, I think using video depositions are much more valuable.
Especially if you're taking the deposition. So if you're taking the deposition and you want information about this witness, you want to be able to examine their body language, you can use those snippets in court. You can put that on as an exhibit and admit the testimony that they have already given you via a video. If my client's giving a deposition, I'm not as excited about doing it via video, and I certainly won't volunteer for us to do it via video.
Well, I
It's
mean,
costs a little bit more money.
but I mean, if your client speaks well and you think that they're going to be effective, then I don't necessarily think there's anything wrong with that per se, especially if your client comes across well and speaks well and is very genuine in their tone. Then I think that it could be very helpful to have the video deposition, actually.
What it certainly communicates to the lawyer is perhaps we should try to settle this case because, you know, he or she makes a very good witness. And it's good to know that before you make a decision of whether or not to go to trial. I think if you're going to a contested trial, in most cases, it does make sense to do a deposition of some sort. It doesn't have to be the whole 4 hours. You get the chance to clarify your answers. Can you talk about that?
Yes, so clarifying your answers. Before the deposition ends, you get the opportunity to read or waive, and I always tell clients make sure that you decide that you want to read, not waive, because once you waive, then you've effectively given away the opportunity to review your answers. Because at the end of the deposition, once it's certified by the transcriber, it's gospel. That's it. That is your testimony, and you cannot change it. So you want to make sure that you always take the opportunity to read, and then within 30, I think you get 30 days here to go over the testimony and then make any changes. If you say, well, that really wasn't my answer, I don't think it was taken down properly, or I didn't say that, I'd like the opportunity to hear back what was recorded before that I agree to sign off on this. It gives you the opportunity to change any answers that you think were not properly transcribed before you sign off on that, because once it's certified, it's gospel, and it will be used against you for impeachment purposes and as substantive evidence in your trial.
Absolutely. This is like the written version of redirect. So in trial, you've got initial testimony, cross-examination, and then redirect. This is a little bit like redirect. Is there anything that you want to take back or clarify or say a little differently? Now let's talk about custody evaluations. And if you also, we don't have a specific slide on court-appointed advisors or parenting conferences, but if you also want to talk about that, I think that would be good for the lawyers to understand and talk about.
Yeah, I seem to be doing a lot of these lately, and they're extremely important and contested custody cases. So you want me to talk a little bit about what a CAA is and what their function is and how we can prepare our clients for that? So yes. A CAA is a court-appointed advisor, and just like it sounds, they're appointed by the court, and in certain cases where there are allegations where maybe one parent has a substance abuse problem or there's abuse in a home, the issue is that courts typically do not like interviewing children. So this is an opportunity for your child to voice his or her feelings, voice concerns that your child might have. So when the court, you file a motion for a court-appointed advisor, and you have to allege certain facts which would convince the judge that a court-appointed advisor is in your family's best interest. And what this individual does, they're very well educated, usually masters in psychologists with a master's degree or a master's in social work. And what they do is they go to each party's home and they interview the parents. And then they interview the children, and then they interview family members, teachers, other witnesses who might have relevant information pertaining to the custody dispute. And they also look at the children's school records. If there's any criminal records, they want to review those. If there's DCS reports, they want to see those. If there's important medical records pertaining to any kind of mental health, they want to see those. And then after they've done their interviews and they've done their research, then they will complete a report for the court, and it will basically tell the court what their position is with regard to parenting time and also legal decision making, which are the two things that parents most fight about: is who gets the kid for the most amount of time and who gets to make the rules, who gets to be in charge.
And so how do you prepare your clients for that? What do you tell your clients before they have a home visit from a CAA?
Well, first thing that I tell them, and it seems like it would be obvious, but it really isn't, believe it or not, is make sure your house looks neat and organized. If you've got a bong out, you might want to put it away. Probably not the best time to leave out any, drug paraphernalia if you have it around. Also, you want to show your court-appointed advisor that your home is a safe place for a child to be living. That is probably one of the key points. Also, I tell my clients, be honest. This is a truth-seeking process, and it's not about in the end who wins. It's about what's in the best interest of the children. So we want our clients to be truthful about what has occurred in the home and why they may or may not be concerned about the other parent's parenting ability.
Absolutely. And then the other thing that I tell clients is before they go in, I want them to understand what are the main points of the case? What do the court-appointed advisor and the judge care most about? And how do we make sure that we talk about that? Because we could talk about our children for a million years. And the difference between a CAA and a CFE, which we're going to talk about next, is a CFE can last forever. With the CAA, you may get one opportunity to talk to this person. So you must be careful not to come off as petty or not to focus on the things that are not most important to get in front of the judge and to get you the recommendation that you need, because the CAA recommendations do have a lot of sway over the court. They're not gospel, but they have a lot of sway.
Yes, that's absolutely true. They have a lot of sway because the CAA will be present at all of your hearings. Once they're appointed by the court, they will be present at all of the hearings, especially evidentiary hearings, and they will be testifying. And I mean, 9 times out of 10, the judges will go with the CAA's recommendation with regard to
9 times out of 10. I don't think you're exaggerating. I think it really is 9 times out of 10.
Yeah.
All right. So let's talk about custody evaluations. Those are, you take the CAA thing we were talking about, and it's a lot more. It's much, much more in depth than the judges will ever get. And then the CAA will ever get. They have enormous power to shape your case, to get documents that the other party might not be disclosing. You can get those also through your CFE, and they can be very important in complex custody cases. So where you've got people who, these are people who might have personality disorders and high levels of dysfunction without that obvious criminality or neglect or child abuse. So custody evaluations include records review, lots of records, site visits, witness interviews, all of that the CAA does as well. But the other thing they do is psychological testing. So this is usually by a doctor who can do psych evals. And psych evals can be a whole lot of different psychological testing. How do you prepare your clients for that?
Oh, wow. Well, there's a lot of different ways. I know I happen to have a lot of cases where there's psychological testing going on. And it's important that obviously that you're truthful with the psychologist, and that if you've been abused or you have any, previous situations in your past that might have occurred, that you're forthcoming with the psychologist, because they do so many different types of tests, MMPI, and there's a battery of tests that they use to determine whether somebody is mentally fit. Oftentimes attorneys file what's called the Rule 63 motion, which is a request for a mental health evaluation. We also have psychosexual evaluations if we believe that one of the parties might have a sexual dysfunction and it's affecting their parenting, then we will request that party undergo a psychosexual evaluation, which is a little bit more intensive. But the way that we prepare is that we try to provide as many records as possible. If there's medical records from that individual's past or the child's past that are pertinent to the case, that we try to provide all of them in advance so that the evaluator can make a well-informed and advised evaluation towards the court.
Yes. So in a lot of ways, you are doing the same thing with the CAA and with the CFE that you would be doing with the judge. You want to convince them of your position. You want to have a strategy. You want them to agree with you. So you want to provide evidence that supports your position. with the psychological testing, one thing that I see a lot is that the results will come back invalid. You tried too hard to look good. And so you really have to tell your clients not to do that, because people who are psychologically normal, who don't have any disorders, might still go in and try to fill out all the right answers and then get an invalid profile, which then raises red flags. So understanding that if you are psychologically healthy, you have nothing to worry about. Go in and be honest. And it would be better for them to say, this person has a history of mild depression and it's treated, or, this person, in the questions, they might ask you things like, what do you do when you feel rage? Just answer, as long as you're not saying I beat children. If the answer is, I need to walk away and take a time or whatever, it's just answer the questions honestly, because the worst thing you can do is try to overinflate your importance and perfection. That won't help you. And you want to be forthcoming about any treatment that you've had, forthcoming about any mental health challenges, any past trauma, and then being open to feedback. One of the things that the evaluators hate the most is when they see the case differently than you, and they try to get you to agree that maybe you had a role in this, or maybe you're seeing it differently, and you tell them, no, they're wrong.
And keep in mind, there's nothing wrong with seeing a therapist. There's nothing wrong with, being on medication. Like what's that quote? There's no shame in the medicine game. And that's true. There's no reason to be ashamed of having a mental health issue. Everybody goes through depression. Everybody goes through anxiety, different periods of their life. And there isn't a taboo in that. So be upfront with your evaluator. If you were seeing a counselor, if you were on antidepressant, there's nothing wrong with taking medication that's gonna help you feel better, and help you feel better will make you a better parent for your children. So be upfront about that, and don't feel like that's something that you need to hide.
Yes. The other ways that I see clients trip up on these is they will be argumentative, defensive, not open to any feedback, and stuck in the past. Those things kill clients in these evaluations. So an unwillingness to look forward, to focus on the future, to focus on your child's current needs. If you're always talking about the things that happened previously and why they'll never be different or never get better, evaluators really hate to see that. And it can lead to some really bad outcomes for clients when that is their position.
That's true. I mean, we had evaluation in one of my cases recently where the other party wasn't being exactly truthful in her answers, and the evaluator knew it, and that came out in the report, and it did not make her look good.
No, not at all. Now let's move on to testifying at trial. Here are my best tips for people. Being able to listen to yourself and hear your tone and hear the words you're using is a great way to start asking yourself, am I showing up the way I want to show up?
That's true. And a good tool to do that is you can, practice answering questions and watch yourself back on video, and you'd be surprised how people's bodies and facial expressions do things that they're not really aware of. So if you can practice, what they say, practice makes perfect, and it's true in this particular case. So it's always beneficial to practice answering questions, and watch your facial expressions, your tone of your voice, the cadence of your speech. These are all factors that will influence the judge's opinion on whether your testimony is credible or not.
Absolutely. And this is where I feel bad for people who are not naturally good speakers, because people who are naturally good speakers, or who practice in their professional life and who do it a lot, simply have a leg up here. So the only way that you can move beyond that is by having someone coach you. And there's some ways to do that. You can use coaching drills. So the second thing here is behavior modifications for habits that don't serve you. Let me give you some examples. If I am coaching, or if Robin's my witness and I'm asking her questions and she's always cutting me off, instead of me telling her not to do that, that's a habit at that point. It's not going to work. You can get something like you can give them a bunch of pennies to start and then take away the money every time they do it. So a physical act, or you get a little bell, like when you walk into an office and you go ding. Well, every time she would do the habit that wasn't serving her, the coach would ding. And that is the fastest way to really break habits that are not serving you. It takes some time, and you can do it with your lawyers. You should be doing this with your clients, but you can also help your clients do it with their spouses or their friends, because it can be hard to stop saying if that is a habit of yours. Do you use any tricks to address bad habits?
I've never done that petty thing or work that I just yell at my client, stop interrupting me. And that usually does the trick, but maybe I'll try your way. It seems to be a little softer. I mean, I think, and you and I have like very different styles, which is good. Every lawyer is different. You don't want your lawyer to be a cookie cutter of somebody else. You want your lawyer to be their own individual, right? And Billie and I have like very different styles. She's like more soft and, funny, goofy. I'm probably can be a little bit more aggressive with my clients. And, I will, when they're being bad, I will tell them so, and we'll try to correct the behavior. But that I like your idea with the pennies. That's actually, or the bell. I might try that.
Yeah. It's funny, Robin, nobody really ever describes me as soft. So that's going to tell our audience a little bit about Robin's style. If I'm soft, now you know Robin is hardcore. And then there are other people who do this. There are witness coaches who just do this. So if your lawyer is, too busy, or if you as a lawyer are too busy or too expensive, and this is not what you want to be doing with your time, then take advantage of the people out there who are witness coaches, who live in this world, who can help your clients. If your client does not have doesn't testify well, and this, if your client doesn't testify well, tell them so that they can invest to get better, because it can make and break a case. Other rules for your clients: you want them to be brief, responsive, and informative. It's okay to be emotional. It's not okay to be unprofessional. And that is a hard line. How do you teach that, Robin?
What to be, not to be, I'm sorry, I didn't get the question, Billie. Sorry. Not to be unprofessional. You mean?
Yeah, so it's okay to be emotional. These are emotional topics, and judges to some extent expect that you're going to have an emotional reaction, and that's okay. But there's a fine line between being emotional and being unprofessional.
Yes. I see what you're saying. It's okay to cry. If you feel sad, cry. There's nothing wrong with expressing your emotion. It makes you appear genuine, because family court it's a very emotional time for people. They're losing time with their children, they're losing their home. It's highly emotionally charged. So be genuine, be yourself, but be professional, be respectful.
Yes, that's where there's no eye rolling, there's no interrupting, there's no you can't do that, you can't write scribbling frivolously, your client can't be tapping you. Like they gotta keep it together. All right, making the most out of your trial date. Take advantage of the tools that are available to you. Be brief, be interesting, be credible. If you speak in a monotone way, stop. Add some intonation. That's more interesting.
Yes, I mean, trial day it's stressful for everybody, especially we're in court all the time. So for us, we're a little bit more used to it. But our clients are not. Sometimes it's their first time ever being in a courthouse. Some have been there a few times, but for the most part, it's the first time being in a courthouse, and it's really intimidating and scary from the minute you walk through the metal detectors, and there's all the security, and then you're going to a cold courtroom, and it's usually really bad wood paneling, and it's very intimidating. And so it's really important that you advise your clients that the most important thing is they take care of themselves, that they have to nourish themselves. And you want to make sure that they get good sleep, get a good night's sleep the night before. Avoid alcohol. I tell my clients no drinking. I know people have a tendency when they're nervous to have a drink to settle their nerves, but I always advise clients, please don't drink. anywhere near your hearing. I want you to be lucid and clear. That's very important. Take time for yourself to meditate. A few minutes of quiet beforehand is always helpful to sort of set the tone for the day and get yourself in a good, safe space mentally. Choosing your outfit wisely, which we discussed before. Please, hide your assets. The judge does not want to see your cleavage, and it's not going to look very good for you if they're popping out. So wear something conservative and show the court that you have respect for being in the courtroom. Speak slowly, clearly. Yeah, that's important. The judge needs to be able to hear you and to hear your testimony. I had a hearing not that long ago where I ordered the transcripts, and halfway through the transcripts, it said inaudible. And I was like, oh my goodness. So I have a transcript that cost the client a lot of money and was very time consuming and is of like little to no value because we couldn't hear what the person was saying. So it wasn't helpful. And then focus on the facts to support your strategy. You only have a limited time in court. You want to lead with your strongest argument.
I'm really glad that you brought up the inaudible. So lawyers, if your clients are testifying and you cannot hear them clearly, it is your job to make your record. It is your job to preserve these issues for appeal. So it would be perfectly appropriate for you to say, sorry, Marilyn, I couldn't hear that clearly. Can you say it again?
Right. And that's important too, going back to the depositions. You always want to give your spiel before you start the deposition that, you can't nod yes or no, and then answer the question. But the court reporter and certainly the audio in the courtroom can't pick up if you're nodding.
Mm-hmm. Absolutely. It's
absolutely or if you're raising your shoulders, like we can't pick that up. So you have to say, I don't know, or I don't recall, and leave it at that.
And that is it. We have time for questions. Thank you so much for being here with us today. Sarah, do we have questions?
Yes, we sent those over to you in the chat.
Oh, I think I see them here.
You see those, Robin?
I did. Oh, here we go. Why does it seem like depositions aren't a super common practice in family court cases? Well, they aren't because they're kind of expensive, or they can be expensive. You have to, there's the cost of your lawyer, and then the other lawyer, and then the court reporter. So they tend to be costly. Plus, a lot of family law attorneys don't know how to conduct proper depositions. It's definitely a skill set, and it can be very intimidating. So oftentimes I think lawyers are afraid to do them, but they're doing their client a disservice because it's one of the best information gathering tools that a lawyer has in his or her arsenal is to conduct depositions. So they should be done more often.
I agree with you. I think not enough lawyers are taught or are comfortable, and because family law judges are used to seeing so many cases, they're used to also seeing people who just kind of can do the bare minimum. And in some cases, that's fine. And in other cases, it's not, because what's on the line here is your future and your children. So it's something to keep in mind. Absolutely. Let's see. The next question we have here is, if the other party lost decision-making and parenting time due to domestic violence, can they come back and gain it back? Robin, you want to handle that one?
Sure. Okay. So if the other party lost decision making, that depends. And I know lawyers say that, people roll their eyes. It depends, but it really does depend. If typically, in a year, courts don't typically like to hear modifications in less than a year's time, unless there's obviously an emergency situation, which warrants going in front of the judge again. But if a substantial time has gone by and that particular individual has gotten anger management, or perhaps attended counseling, or done something to curb their behavior, then they would have the opportunity to seek more time with the children, but on kind of a step up level. Beginning with supervised visitation, where there's a supervisor there, or at a supervising agency, to gradual unsupervised time and then possible overnights if it's a safe environment for the children to be in. And the other part of the question, if they continue to harass you and allow their spouse to assault you in front of the kids, oh, well, that's a problem. Anytime a child observes domestic violence, not necessarily a victim, but even when they observe domestic violence, that's a problem. And so if there is, physical aggression going on and children are observing that, then that would certainly come into play and trying to prevent the other parent from getting unsupervised time with the child. And certainly not having any legal decision making. We have a statute here. It's 25403, and it talks about the balancing test for best interest of the children. And if there is substantial domestic violence or any domestic violence within the year, then that particular parent, there's a rebuttable presumption that that parent should not have shared joint legal decision making.
Here's some other good questions. One question is, should you have your attorney present with you at a CAA meeting? Now, you recently met with your client and DCS, which is not the subject of today, but it is related. When should the lawyer be present?
I've never been present with the meeting with the CAA, and I don't know that you can, to be honest with you. I prepared my client, and I've also sent relevant information to the CAA. Like, for example, before the CAA meets with my client, I will send them a copy of all the relevant pleadings and then any exhibits that I believe are pertinent and germane to the case, that if there's medical records or if there's an order of protection, or if there's photographs, or if there's school records that the CAA needs to use in order to evaluate the particular family, then I will send those to the CAA previously. But I've never met with the CAA and my client simultaneously.
I'm glad that they brought it up, because I think you can. I don't think there's any prohibition against having your attorney present, and you may even have a right to have your attorney present. They might not like it. It might backfire. So you would really have to think about the pros and cons. What am I gaining and what am I trying to do by having my lawyer present? Am I afraid that, perhaps you have a client who does not articulate themselves well. They're not a good speaker. They shut down. They don't come off well. You, as their lawyer, may want to show up as a buffer to help interpret, to help pull out the information that that maybe they're not offering. I could really see some advantages to that. And I really liked that you did that when you met with your client in DCS.
Yeah, that was an unusual situation. DCS doesn't usually like to talk to lawyers.
Right.
I can't imagine why, but but I did have a situation, last year where there was an allegation made and DCS got involved, and I wanted to be there because I felt like I could help tell the story, and I felt like my client maybe that person was nervous and would leave out critical pieces of information that were very relevant, and I was told I could be there, but I wasn't allowed to speak. And anybody who knows me knows that I'm not like baby in the corner. I will sometimes, articulate my thoughts about particular topics. So after the interview was completed, I did interject, and I did, let them know that there were, particular pieces of evidence and exhibits that I believed were needed to be taken into consideration. And the DCS worker told me that I could email them to her, and I did. And about 3 days later, the case was dropped. So I think it was effective and helpful in this particular situation. But let them do their job. I mean, we don't want to obviously interfere with their investigation. I mean, they provide a valuable, resource for our community and helping keep children safe. So we want to let them do their job. But sometimes they don't have all the information needed in order to make the determination. So if we can provide that, then I think that's extremely beneficial to our clients.
And I think the same logic might apply to some CAA meetings. So it's something to consider. I'm glad that this person brought it up. The next
me too.
question we've got is, do you do discovery like depositions before requesting a trial? Because perhaps the discovery can help the parties understand the weaknesses of their case and make them more likely to compromise and settle a disputed issue to avoid a trial.
That was a compound question. Who wrote
I
that?
completely agree with you.
Let's take that bite by bite. I'm not seeing it here. So let's do the first part because I need to.
Well, the answer is yes. Can you do discovery before requesting a trial? Absolutely.
Yeah, you have to actually. You have to do discovery before requesting a trial. You'll get a judge very upset with you if you file a certificate of readiness for trial and you haven't completed discovery yet. Plan to get a very nasty order back from the judge denying your request. Yeah, so just all discovery has to be completed before you can go to trial. Certain states like in Florida, where I'm also licensed, you can't even go to trial until you've done mediation. So you have to check that box before getting to trial. Here, it's not required. I mean, I think it's best practice in certain situations. At the very least, it helps you limit the issues. If you can agree to maybe child support and spousal maintenance, but not parenting time, at least you've taken half the problems off the table. And that way, when you go to trial, you don't have to take testimony on as many issues because you've been able to resolve some of them. But you should always conduct all of your discovery prior to mediation and then trial.
Ooh, what if we know someone sent the other parent to do a hair follicle test, but they used somebody else's hair? We don't have proof. Do we mention it at trial?
That's an interesting. What if we know the other parent sent someone else to do a hair follicle test? Well, I mean, I would bring it up at trial with the judge. I mean, yes, that's going to be hard. Well, I mean, that's an interesting question. I don't think I've ever been asked that before. People do lots of underhanded, sneaky things when it comes to drug and alcohol tests. That's for sure. So what I would do in that particular situation is I would file a motion with the court requesting a court-ordered hair follicle test instead. So the person would have to go down to the court-ordered facility, present their identification, and then they're monitored when the test is taken. I think that would be a solution to that particular problem. Billie, do you have any other thoughts on that one?
No, I wouldn't wait till trial to bring it up. So this is why you should file a motion. You should file a motion to ask for retesting, ask for a different facility. You may get ordered to pay for it. Your request may be denied, but if you think that somebody is messing with drug tests, that's probably the way to go. The other thing is a drug test is not the only way to get evidence of drug use. So always think about that. Always think about what are the other ways I can get this evidence? Are there witnesses? Are there transactions? Are there Facebook posts? Are there social media posts? How can I get evidence to support what I'm trying to prove? And then the other thing is, are you trying to prove that they use drugs, or are you trying to prove they're an unfit parent? So really think about, what am I trying to prove? What am I using this evidence for? What else can I get? Okay, so there are other questions here that are kind of off topic. So we might address those in our Facebook group. But there was one question: does a TI do a psych eval? Not usually. Their job isn't to do an analysis. Their job is to reunify parents and children. So no, they wouldn't do a psych eval. What if your spouse denies cheating at a deposition? Well, what do you think?
I'm sure that's not the first time that's happened.
So that is a good thing. If you catch people lying at a deposition, you get to impeach them. You get to show the judge that they're a liar with your other evidence. So many times people will lie in depositions about their answers. Now, is the fact that your spouse cheated on you relevant by itself without anything else? No. So what is the real actual fallout of them lying about it? Nothing. But you're going to have more than that.
Yeah, but it also goes to credibility too. I mean, if if it's obvious that they're lying and you've caught, they've testified one way in a deposition, and then they said, no, I'm not having, I didn't have an affair, but then you pulled, bank records of purchases of jewelry and other items that you never received. So then it shows the judge that the person's not being truthful. So while, because Arizona is a no-fault state, so that's not grounds for a divorce. But it does play a factor in marital waste. If one party is spending a lot of money on their paramour, then that the other spouse would be entitled to 50% of whatever was spent on that marital waste. And then also it could affect parenting time. I mean, it could affect parenting time with regard to, is that other parent making the best decisions? And do I want this person around my child? If the person could, if the paramour is a dangerous type of individual, then that would absolutely play a role in whether or not the judge awards that parent unsupervised time with the child.
Absolutely. Thank you all so much for being here today. We hope that this was helpful. If there are other topics that you would like us to cover in our CLE series, please let us know. Thank you for being here.
Thank you.
Bye.
Bye, everyone.